You're listening to Planet Green Trees. The call number is 1-347-326-9626. We've got 1 hour and 23 minutes left in the show, and we are going to go to our special guest, my friend Neil Rockind. Neil, of course, has been successful throughout Michigan in the practice of law, criminal defense, and just as recently won a dismissal in a dispensary case, clinical relief, getting the judge to dismiss the charges, Oakland County. And also, what will probably stand right now as one of the greatest victories, the dismissal of charges on the operating while having the presence of a controlled substance, and that charge be nullified. He'll correct me, I know it's in the exact way, because cannabis is no longer a controlled substance. And with that being said, Rockstar Alert, Neil Rockind. Thanks for being on, Neil.
Hi, how are you?
Hey, thanks for calling in.
Hello, Neil.
Oh, my pleasure. Listen, anytime I can be, it's springtime or almost springtime, and the trees are in bloom, and I can't think of a better place to be than hanging out, at least on the phone with my friend Mike Komorn in Green Trees. So thanks for having me.
On the planet.
So, Neil, I want to hear what's been going on with you, but, I was thrown out there with this topic. It came up. It was in the news a while ago. And the issue with the guns and medical cannabis patients. I'd mentioned before this case that's now I got involved in, but also there's some case law and reference out of Oregon where it went to the Supreme Court. They ruled in favor of the patient and the pistol holder. But our community is scared out of its mind, and it's challenging. And I'm sure you get a lot of the same calls. What are your thoughts on that stuff?
Well, I think that the ATF made much ado about nothing, and unfortunately, when it issued a letter, which was a policy letter, we have discovered, local leaders, prosecutors, and police officials took what was a policy statement by the ATF, the Bureau of Alcohol, Tobacco, and Firearms, and took that policy statement and then extrapolated from that, like 15-fold. It's almost like they decided that, if you could saw someone a kid floating in water, that if the local officials, by analogy, saw the person floating in water, they would think, my God, that person is can swim like across the English Channel. The policy statement just simply said that, there was an issue with that there's no right to possess firearms under federal law if you, what it really said was that if you go to a gun dealer and the gun dealer has to ask you a question about whether or not you use marijuana, whether it's medicinal or otherwise, and you answer the question yes, then the gun dealer should prohibit you from purchasing a firearm. And that was really the crux of the policy statement. And what state officials have since concluded in Michigan, at least, is that if you're a medical marijuana patient and you apply for a gun, or you have a gun, or you have a permit, that somehow the fact that you use marijuana for medicinal purposes means that you're addicted to marijuana, and therefore the answer to the question, are you addicted to a controlled substance, must be answered in the affirmative, and therefore you should be denied a gun or a permit. And in Oregon, the Oregon Supreme Court said, just was spot on and said two things. They said, first of all, don't read an opinion we issued a year ago to mean anything more than what we said a year ago. And when it comes to sheriffs and the issuance of permits to carry firearms, Oregon law controls. In Oregon law said that if you're otherwise qualified with no prior convictions and no PPOs or restraining orders issued against you, then you qualify to carry a firearm. And that's all it said. It said,
right, I looked at it again.
It's very simple. It's so simple.
They narrowed it and they said, look, the sheriff's job is to create a criteria, evaluate whether people meet it or not, and issue a license. And don't think beyond that. That's essentially what
right. That's it. And what these sheriffs are all they take something that's said as an aside, and then they just kind of extrapolate from it, and they decide to have a broad policy based on it.
You know,
Look,
it's funny.
as far as I'm concerned, here you get a Second Amendment right to carry or to possess a gun and to use a gun in your own self-defense. You have a Second Amendment right to have a firearm in your home to protect your home. And somebody somewhere in Michigan at some point is going to litigate the issue of whether or not a gun board can properly deny a marijuana patient marijuana patient from possessing a firearm. I mean, that issue is going to be litigated.
We're doing it now. That's the thing. You didn't hear the beginning of the rant. That's what I was talking about. I got this case now. I thought I may have mentioned to you, but it's right on point with that. And they said to him very, very clearly, sir, there's nothing about any reason why you're here other than we've learned that you're a medical marijuana patient. The ATF would call you, it's not us, would call you a drug addict, addicted to a drug. You meet the criterion on this application that fits this criteria. We're not quite sure what we're going to do. And it's kind of interesting. I'll tell you what was really distressing today. I called up because I'm submitting some materials, and they're going to give me a chance to argue on our side a little bit. And whatever happens, it's we have a right to go to the circuit court, and I'm sure it'll work its way up. But the clerk had mentioned that I said, the attorney representing the prosecutor's office had mentioned that there was an internal memo that had gone around, and I wanted to get a chance to take a look at that. And she said, no, the only thing that they were talking about was whether or not when the gun board learned that a person was a patient, whether or not they were required to enter that into the lien system. Now think about where that's going, okay?
Yeah, I can see where it's going.
Yeah,
right.
It's not good. But anyways, enough about that. That was another topic. I know.
So I know, Mike. You're first of all, I know you're doing great things. I happened to catch your speech before the House Judiciary Committee when you spoke was as good as I've ever heard you. So you were spot on, and I give you credit for that.
Thank you very much. I appreciate it.
Yeah, I mean, you were spot on. So
you were fantastic as well, and you were given a very challenging
Tom Loeb
situation.
took too much of my time, right?
Right.
But you can blame Loeb. I blamed him the entire car ride back. The poor guy, his right ear was bleeding from listening to me bitch about how much he, took all my time. But that's okay. Look at what's that?
He rolled over you.
His earlobe. So the point is that I hope that the legislators are at least hearing what we're talking about in terms of some of their bills. But the most important thing for me, and I get this all the time. Here's the interesting thing that I hope that people, patients and caregivers, understand that they're. At one moment, there's Neil Rockind, who is a medical marijuana advocate, and I advocate for people to be able to medicate, and in fact, I argue that they should be able to alleviate their own pain and their own suffering in whatever way they can. And if it's marijuana, if it's cannabis, God bless them. Life is hard enough without being able to, with having the government tell you what you can and can't use. So you can go have 2 bottles of wine and drink yourself into a stupor, but you can't actually, smoke a marijuana cigarette, for 2 minutes is preposterous to me. But so there's marijuana advocate, and then on the other hand, there's the lawyer who represents an individual client, and those are challenging because we want to help. As Mike, you want to help every client that comes before you, whatever the issue is, whatever the case is about, and whatever the And for some clients, there are great medical marijuana defenses, and for some others, there aren't. You and I would both love to see every client of ours get a medical marijuana defense before a jury, but I know that one of the issues that I hope that people understand is that when there's, when Mike Komorn is out there banging your drum on the Capitol steps, that by the same token, you're not going to take some client of yours and throw your client to the wolves if they have a terrible case. You're going to do what you can to protect your client because that's your job.
Let's talk about this. I've been seeing this. We don't know how these bills are going to work themselves out. One of the main bills, and in addition to it being a topic of conversation amongst this Judiciary Committee, but also because of that recent Lara memorandum, obviously there's a lot of focus on the doctor-patient relationship, and whatever that means, the bona fide doctor-patient relationship. And one of the things that struck me is on that the last day in time, last Thursday, they had a representative there. Jimmy, you'd spoken to him before. What was that guy's name from the Michigan Health, the Medical Society?
Michigan State Medical Society. Gordon.
Colin Ford.
Colin
Ford. Yeah.
He seemed to, we were taking the position that they didn't need to change the doctor-patient relationship by way of legislation, that the Lara memorandum sufficed. You had doctors that were providing guidance. Yeah. And this should also encourage other doctors to maybe come forward, because now some standards have been set, we would hope. And by creating a law that allows law enforcement to arrest, but this individual from the Michigan State Medical Society said that they did not have the authority to oversee anything other than the certification, which is absurd in light of the fact that they sent out this memorandum which told them how to do the certifications. You know what I mean? It was very, very...
well, part of it, I mean, if we can get back to square one, part of it is, and this is one of the issues I think that we're experiencing in court, and I'm going to kind of tie two issues together. The whole premise behind the ability of a doctor to recommend medical marijuana is premised on that every physician, whether they're a physician or not, has the right under the First Amendment to express an opinion. And all the medical marijuana certification is supposed to be, as the law was originally envisioned, was that a doctor defined as an osteopath or as a medical doctor would offer an opinion, which they're allowed to offer under the First Amendment, that a particular patient would likely receive benefit, be it palliative or otherwise, from the use of medical marijuana.